Namaskar, brothers and sisters, ladies and gentlemen, students and scholars, teachers and trainers, professors, professionals, listener learners, officer officials. I welcome all respected doctors and directors. I welcome adorable ministers and managers. I welcome all honorable advocates, retired administrative advisors. I welcome the most honorable present Prime Minister Modi ji. It is really nice time, nice place, nice action today that we are describing, explaining, describing our holy Indian cultural identities in the form of unity and diversity. India to abroad, in the different universities where our Indian scholars are studying, they are learning research. What's the true research? That is to go in deep of our insight. Dear friends, let's go through the holy Indian Constitution. Criminology and Criminal Justice Administration. Let's discuss the effect of mass media on criminality. The present age is the age of mass media. In this age, newspapers, television, cinema, radio, and internet occupy an important place. The mass media affect the general public comprehensively. The newspapers encourage crime. Valerie Land has to say that crime news does encourage delinquency and crime. According to Professor Taft, newspapers affect the crimes. How? By making familiar with the technique of commitment of crime, by making the criminal more attractive, profitable, and exciting, by conferring honor upon the criminal, by awakening the sympathy and the concept of individual worship towards the criminal, by reflecting the criminal elements in the culture, by indicating the judicial system as a mockery, by popularizing the ineffective method of correction of criminals. The same is the position of television, cinema, and internet. In television and cinema, films with all scene and sexual scene are shown. The scene of murder, dacoity, looting, and rape are shown. Internet has given birth to cyber crimes. W.D. Ball has to say that the criminal effect of cinema is deep on that person who experiences more emotional instability and tensions. Let's express our views on religion and crime. Religion and crime are indicators of opposite questions. Religion has its relationship with morality, while crime with immorality. When a person deviates with morality, then he commits crime, some like sex, anger, proud, affection, greed, lust, and selfishness are immoral and non religious instincts which give birth to crimes. Thus, there is a deep relationship between religion and crime. A religious person can never commit a crime because his life is full of morality. As soon as he deviates from the path of morality, he becomes a criminal. Therefore, it can be said that one of the reasons for the crimes is the moral and character degradation of the person. Where is it? When wealth is lost, nothing is lost. When health is lost, something is lost. But when character is lost, everything is lost. A religious person is brave. He is afraid of immoral acts and crimes. He considers them a sin. This is the reason that now religion and morality are taught in prisons and religious ceremonies are organized. Rajasthan Police Act 2007. Let's mention the definitions given in section 2 of the Rajasthan Police Act 2007. The definitions of these words have been given in section 2 of the Rajasthan Police Act 2007. In this act, unless the context otherwise requires, Chief Secretary means the Chief Secretary to the state government. Cybercrime shall mean and include all offences under the Information Technology Act 2000, Central Act number 21 of 2000, and any other offence committed by use of electronic devices such as computers, credit cards, internet ATM, etc. Director General of Police means the police officer appointed as such by the state government for the overall control, supervision, and direction of the police force. DGP, DSP, District Superintendent of Police, means the police officer in charge of a police district. Police officer in charge of a police district. DSP. Domestic help. Domestic help means a person working for remuneration or otherwise in a household. Moral turpitude means involvement in any crime which pertains to cheating, forgery, intoxication, rape, outraging the modesty of a woman, illicit traffic as defined in the Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act 1988, Central Act number 26 of 1988, immoral trafficking as defined in the Immoral Traffic Prevention Act 1956, Central Act number 104 of 1956, planned violence or any offense against the state as mentioned in chapter 6 of the Indian Penal Code 1806, Central Act number 45 of 1860. Organized crime includes any crime committed by two or more persons in pursuance of their common intention of wrongful or unlawful gain. That is organized crime. Outpost means a police post within the jurisdiction of a police station. Outpost means a police post within the jurisdiction of a police station. Police officer means any member of the police force of the state. Any member of the police force of the state, that is called police officer. Police personnel shall include police officers and all other persons for whom the appointing authority is the Director General of Police or an officer subordinate to him. Police station means any area declared to be a police station under the provision of the Code of Criminal Procedure 1973, Central Act number 2 of 1974. Power of superintendence means and includes power of giving directions, guidance and instruction, endeavors, resign or revise any order issued by any authority under the provisions of this act, subject to the provisions pertaining to the investigation as contained in the Criminal Procedure Code 1973, Central Act number 2 of the 1974. Prescribed means prescribed by the rules made by the state government under this act. Public place means any place to which the public had access. Railways area. Railway areas means areas comprised between outermost signals, apartments to railways, tracks including premises of every railway station within the state of Rajasthan and shall include trains on tracks, whether moving or stationary, in any area of the state of Rajasthan. Ranks shall mean and include subordinate ranks and supervisory ranks. Rules means the rules made under this act. Special shall means a shall created for dealing with a particular category of crime or providing better service to the community, including victims of crime. State means the state of Rajasthan. State government means state government of Rajasthan. Subordinate ranks means all ranks below the rank of assistant or deputy superintendent of police. Supervisory ranks means ranks of assistant and deputy superintendent of police or above. Tenant for the purposes of this act means a persons to whom a house or premises or part thereof has been let out, whether a lease or rent deed has been executed or not, and village guard means a person enlisted as such under section 48 of this act. Two is the words and expressions used but not defined in this act shall have the meaning as assigned to them in the Code of Criminal Procedure 1973, Central Act number 2 of 1974, and the Indian Penal Code 1860, Central Act number 45 of 1860. Let's discuss the functions, duties, and responsibilities of police officers in section 29 to 41 of the Rajasthan Police Act 2007. The functions, duties, and responsibilities of police officers have been mentioned, namely functions, duties, and responsibilities of police officer. One is the following shall be the functions, duties, and responsibilities of a police officer. Two is to enforce the law. The following shall be the functions, duties, and responsibilities of a police officer: to enforce the law and to protect life, liberty, property, rights, dignity, and human rights of the people, to prevent crime and public nuisance, to maintain public order, to pursue internal security, prevent and control terrorist activities, and to prevent breach of public peace, to protect public property, to detect offences and bring the offenders to justice, to apprehend persons whom he is legally authorized to apprehend, and for those apprehension sufficient grounds exist to help people in situations arising out of natural or man-made disaster, and to assist other agencies in relief measures, to facilitate orderly movement of life, to facilitate orderly movement of people and vehicle, and to control the regulate traffic. Together, intelligence relating to matters affecting public peace and crime, to provide security to public authorities in discharging their functions and duties, and to perform such duties and discharge such responsibilities as may be enjoined upon him by law or by any authority empowered to issue such directions under any law. The state government or an authority especially empowered behalf of in this behalf by the state government may assign such other duties and responsibilities to police officers as may be specified by the state government section number 29. Special responsibilities of the police officer. Every police officer shall behave with the members of the public with due courtesy and decorum, particularly so in dealing with senior citizens, women, children, and members of weaker sections of society. Guide and assist members of the public, particularly senior citizens, women, children, and the physically or mentally challenged individuals who are found in helpless condition on the streets or other public places, provide requisite assistance to victims of crime and of road accidents, prevent harassment of senior citizens, women, and children in public places and public transport, including stalking, making objectionable gestures, signs, remarks, or harassment caused in any way, render lawful assistance to the members of the public, particularly women, children, and members of the weaker section of the society. In its explanation, senior citizen means a person of and above the age of 65 years. Section 30, recording of information in cognizable cases. The officer in charge of a police station shall promptly receive and record every information relating to the commission of a cognizable offense in accordance with the provisions of the Code of Criminal Procedure 1973, Central Act number 2 of 1974, where any person sends or gives information to the district superintendent of police of the facts which prima facie constitute a cognizable offense and alleges that the officer in charge of the police station having jurisdiction has refused to record the information, the district superintendent of police shall immediately proceed to take or cause to be taken disciplinary action as per rules against the officer in charge of the police station. Any punishment awarded in the said disciplinary proceedings shall be recorded in the service record of the concerned officer and shall be considered always when his efficiency and performance is required to be adjudged. Section 31, senior police officer performing duties of a subordinate police officer. A senior police officer may perform any duty assigned by law or by a lawful order to any other subordinate to him. And in case of any duty imposed on such subordinate, a superior officer may add, supplement, supersede, or prevent any action of such subordinate by his own action or that of any person lawfully acting under his command or authority, whenever the same shall appear necessary or expedient for giving more complete or convenient effect to the law or for avoiding any infringement thereof. Section 32. Police officer always on duty. Every police officer shall be considered to be always on duty for all purposes of this act. Section 33. Police officers may be deployed in any part of the state. Every police officer may at any time be deployed as a police officer in any part of the state. Section 34. Police officer not to engage in other employment. No police officer shall engage in an employment or office whatsoever other than his duties under this act unless expressly permitted to do so in writing by the state government. Section 35. Police officers not to withdraw from duty. No police officer shall be at liberty to withdraw himself from duties of his office unless expressly allowed to do so by an officer authorized to grant such permission. Section 36. Police officer may lay information before a magistrate. It shall be lawful for any police officer to lay any information before a magistrate having jurisdiction and to apply for a summon, warrant, search warrant, or such other legal processes as may by law be issued against any person committing an offence. Section 37. Police officers to take charge of unclaimed property. One is, it shall be the duty of every police officer to take charge of unclaimed property and to furnish an inventory thereof to the police station having jurisdiction. Two is, the manner of disposal of such property shall be such as may be prescribed. In its explanation for the purposes of this section, property shall mean any movable property, property, money, or valuable security. Section 38. Police officers to keep diary. It shall be the duty of every officer in charge of a police station or an outpost to keep a general diary in such form and manner as may be prescribed. Section 39. The state government may prescribe the form of returns. One is, the state government may prescribe the forms and the manner of returns to be submitted to it by the Director General of Police. The Director General of Police (DGP) may specify the forms and manner of returns to be furnished to him by other police officers. Section 40. Uniforms, insignia, accoutrements, etc. The state government may prescribe uniform, insignia, and accoutrements of our police officers, or as the case may be, a class of police officers. The Director General of Police may from time to time issue directions for wearing of uniforms and carrying of insignia and accoutrements. Section 41. What provisions have been made in the Rajasthan Police Act 2007 regarding village guards? Let's explain. In the section 48 to 54 of the Rajasthan Police Act 2007, provisions have been made regarding village guards, namely enlistment of village guards in rural areas. One is, the district superintendent of police may, in the manner prescribed, enlist a person to function as a village guard for a village or a group of villages in a police district under his charge. Two is, able-bodied persons not below the age of 30 years and above the age of 55 years at the time of such enlistment and residing in a village, or in the case of a group of villages in a village of the group, may be enlisted as village guards. The district superintendent of police shall observe the following order of preference in the process of enlistment, namely, an employee of the state government, subject to the prior approval of the head of the department thereof for such enlistment, subject to the prior approval of the head of his office for such listing, an employer of any local body or any other institutional owned or subsidiary or substantially controlled by the central or state government. Home guard, volunteer, ex serviceman. A person shall not be enlisted as village guard if he has been convicted for an offence involving moral turpitude. A criminal case has been registered and is pending against him. He is member of a political party or its affiliate, or he does not possess such educational qualification as may be prescribed section 48. Tenure of village guard. A person enlisted as a village guard will have a tenure of 3 years. The tenure shall not be extended or renewed, provided that a village guard shall be summarily removed from the assignment at any time during the currency of his enlistment if he incurs any of the ineligibilities specified in subsection 4 of section 48 or found negligent in discharge of his duties and responsibilities as village guard section 49. Duties and responsibilities of village guards. The duties and responsibilities of village guards will include: one is reporting the occurrence of any crime or law and order situation in the village at the earliest to the police station and assisting the police in bringing the offenders to book. Maintaining a general vigil in the village from the point of view of crime prevention or prevention of a law and order problem and promptly informing the police station about the same. Remaining alert and sensitive to any information about any suspicious activity, movement of suspicious person, or development of any conspiracy in the villages that is likely to lead to a crime or breach of law and order, and promptly passing on such information to the police station. Assist a private person authorized to arrest a person under section 45 under section 43 of the Code of Criminal Procedure 1973 Central Act number 2 of 1974 in arresting such person and handing over him to a police officer or as the case may be in taking him to the nearest police station along with any arms, ammunition, property or any other object found in his possession or on his person, provided that if the offender is a woman, a male village guard shall be accompanied by a woman. Securing and preserving the scene of any crime till the arrival of the police duty, censoring that it is not disturbed by curious onlookers or anyone else. Meeting the officer in charge meeting the officer in charge of the police station at a minimum frequency as prescribed by the superintendent of police through a general or special order to report on such activities and incidents in the villages as would have a bearing on crime, law and order, or other policing concern. Maintaining the prescribed records and registers, recording any public grievances or complaints in the relation to policing, liaising with the village panchayat on matters relating to crime and law and order in the village section 50. Training of village guards. The superintendent of police shall ensure that every person on his induction as a village guard is administered such training course and for such period as may be determined by the Director General of Police Section 51. Oaths or affirmation by village guards. Every person enlisted as a village guard shall take shall take an oath on affirmation. Take on shall take an oath or affirmation as may be prescribed before the officer in charge of the police station concerned section 52. Village guard to an honorary worker. A village guard shall be an honorary worker and shall be deemed to be a police seemed to be a public servant within the meaning of the Section 21 of the Indian Penal Code 1860, Act number 45 of 1860. A village guard may be paid such honorarium and out of pocket expenses as may be determined by the state government. Section 53. Identification of village guard. Every village guard shall be provided an identity badge, and a photo identity card in such forms and manner as may be prescribed. To is every village guard shall always wear the identity badge and keep the photo identity card with him while he is in chains. He is engaged in discharging his functions and responsibilities under this act. Any person who ceases to be a village guard shall forthwith deliver to the district superintendent of police or to an officer authorized by him his identity badge and photo identity card. Section 54. What provisions has been made in the Rajasthan Police Act 2007 regarding the following? One is community license group, two is offences and penalties, three is police accountability.
UHF is waiting for connection. UHF is waiting for connection. Bluetooth is waiting for connection.
Identification of village guard. Every village guard shall be provided an identity badge and a photo identity card in such form and manner as may be prescribed. Every village guard shall always wear the identity badge and keep the photo identity card with him while he is engaged in discharging his functions and responsibilities under this Act. Any person who ceases to be village guard shall forthwith deliver to the district superintendent of police or to an officer authorized by him his identity badge and photo identity card. Section 54. What provision had been made in the Rajasthan Police Act 2007 regarding the following? One is community liaison group. One is the district superintendent of police shall constitute in the manner described one or more community liaison group consisting of representatives of the community for each police station to aid and assist the police force in the charge of in the discharge of its function, provided that at least one community license group shall be constituted for every panchayat, whose community license group shall perform functions and have responsibilities as may be prescribed section 55 to its offences and penalties. One is punishment for certain offences on roads, etc. Any person who on any road or in any open place or street or thoroughfare within the limits of any town to which this section shall be specially extended by the state government commits any of the following offences to the obstruction, inconvenience, annoyance, risk, danger or damage of the residents or passengers shall, on conviction before a magistrate, be liable to a fine not exceeding 50 rupees or to imprisonment with or without hard labor not exceeding 8 days, and it shall be lawful for any police officer to take into custody without a warrant any person who within his view commits any of such offences. Slaughtering tattles, furious, riding, etc. First, any person who slaughters an cattle or cleans any carcasses, any person who rides or drives any cattle recklessly or furiously or trains or breaks any horse or other cattle, cruelty to animals. Second, any person who wantonly or cruelly beats, abuses or tortures any animals obstructing passengers. Third, any person who keeps any cattle or convenience to of any person who keeps any cattle or convenience of any kind standing longer than is required for loading or unloading or for taking up or taking down passengers, or who leaves any convenience in such a manner as to cause inconvenience or danger to the public. Exposing goods for sale. Fourth, any person who exposes any goods for sale. Throwing dirt into street filth. Throwing dirt into street, it is the fifth. Any person who throws or lay down any dirt, filled rubbish or any stone or building materials, or who constructs any cowshed, stable or the like, or who causes any offensive matter to run from any house, factory, dung heap or the like, being found riotous. Sixth, any person who is found riotous, indecent exposure of person. Seventh, indecent exposure of person. Seven, any person who willfully and indecently exposes his person or any offensive deformity or disease or commits nuisance by easing himself or by bathing or washing any tank or reservoir not being a place set apart for that purpose, neglect to protect dangerous places. It is neglect to protect dangerous places. Any person who neglect to fence in any person who neglect to fence or in or duly to protect any well, tank or other dangerous place or structure. Section 16. Punishment for being found drunk. A person who on any road or in any open place or street or throughout fair within the limits of any town to which this section shall be specially extended by the state government is found drunk and incapable of taking care of himself to the obstruction, inconvenience, annoyance, risk, danger or damage to the residents or passengers shall, on conviction before a magistrate, be liable to a fine not exceeding 500 rupees for the first offence, a fine not exceeding 5,000 rupees for every subsequent offence after conviction of third offence, or to imprisonment with or without hard labour not exceeding 8 days, or it shall be lawful for any police officer to take into custody without a warrant any person who within his view commits such offence. Section 60A. Unauthorized use of police uniform. Whoever, not being a police officer, wears a police uniform or any dress having the appearance or bearing of any of the distinctive marks of that uniform without being authorized by the state government, or as the case may be, an officer authorized by the state government shall be punished with punishment imprisonment not exceeding 6 months, or with fine, or with both. Section 61. Police accountability. One is the state government may, as soon as may be, establish a state police accountability committee, hereinafter referred to as state committee, and district accountability committee, hereinafter referred to as district committee, for each district or group of districts. The chairman and the members of the committee established under this section may be paid such honorarium and out-of-pocket expenses as the state government may from time to time determined by a general or special order. International human rights. Let's explain the concept of human rights. Is human rights a legal right? Human is a social animal. He is wise and rational. It is the reason that he has some rights from birth. He cannot be deprived from these rights. It can also say that to imagine a person without rights is meaningless. Famous jurist N.A. Paliwala well said that liberty lies in the heart of man and woman. Liberty will not die before the man. When it dies, then no constitution, no law, no court can save it. No constitution, no law, no court, even much do it help to it. Can even much do to help it. And a Palkiwala, our constitution defaced and defied. This freedom is rights. These rights are addressed by many names. One is human rights, two is fundamental rights, three is basic rights, and four is natural rights, five is inherent rights, and six is birth rights. No matter what name is given to these human rights, but they are soul rights. Without this, no imagination of existence of human. A person's physical, mental, and intellectual development depends upon these rights. Not only this, even a person's moral, social, and material development also depends on it. In 1993 in Vienna, it was said in a World Human Rights Conference that all human rights derive from the dignity and worth inherent in the human person, and that the human person is the central subject of human rights and fundamental freedoms. G.D. Basu, Human Rights in Constitution Law, edition 1995, page 5. Human rights are those minimum rights which every individual must have against the states or other public authority by virtue of his being a member of human family, irrespective of any other consideration, such as human rights, necessarily depends upon primary human needs for the overall development and benefit of person. These rights are mandatory. The protection of these rights are expected. It is an important achievement of modern international law to provide organization to dignity and respect of human person have international protection to maintain their human dignity. United Nations is committed to increase the honors of human rights and basic freedoms. The form of human rights is three types: legal, moral, and political. Human rights are legal because it consists execution of rights which is described in international treaties. It is moral because human rights are the value-based system to provide protection to human dignity. Today, the circle of human rights is very wide. In this matter, Supreme Court decided that every woman's right to privacy, dignity, and bodily integrity should be respected. Suchitra Srivastava versus Chandigarh Administration, AR 2010, SC 235. The concept of human rights are consist in following rights. One is civil and political right. Civil rights mean such rights which are related to the protection of right to life and personal liberty. These rights are important for everyone so that they can live a respectful and life of dignity. Mainly civil rights are following. One is right to life, liberty and security. Two is privacy. Three is possessing of property. Four is freedom from inhuman treatment. Five is freedom from torture. Six is freedom of opinion and speech. Seven is freedom to marry. Eighth is right to correspondence. Ninth is freedom of thought, conscience and religion. Political rights means a person's right of participation in political matters. Right to vote. One is right to vote, two is right to be elected. Right to vote, right to be elected in election, three is right to take part in the conduct of public affairs. To determine the execution of these rights, International Covenant on Civil and Political Rights 1966 was adopted. Economic and Economic, social and cultural rights. Economic, social and cultural rights are mandatory rights of human life. The existence of human life cannot be imagined without it. The existence of human life cannot be imagined without it. Economic, social and cultural rights. These rights are related to food, clothes, residence, right to work, right to social security, right to physical and mental health, right to education, right to proper life stage. To determine the execution of these, to determine the execution of these rights, International Covenant on Economic, Social and Cultural Rights 1966 was adopted in. Is human right a legal right? Here a question arises that whether human right is a legal right. Legal rights has basically two elements. First, bearer of right and second, person bounded by the duty. Right and duty are complementary to each other. In this way, human right is a legal right because human is a bearer of human rights and it is the duty of state to protect these rights. It was said in the Declaration on the Human Rights Defender adopted by United Nations General Assembly on 9th December 1998. that it is primary duty of states to adopt necessary measures for the protection, increment, and execution of human rights. To determine all this, every state must accept necessary law, administration, and other steps. International Covenant on Economic, Social, and Cultural Rights, on Civil and Political Rights, and International Covenant on Economic, Social, and Cultural Rights are its burning example. Tukaram Kana Joshi versus MID Sikh Air 2013 Section 565. In this matter, Supreme Court decided that right to property is human right. PTM Reddy versus Revima AIR 2007 SC 1753. In this matter, Supreme Court said that right to property is not only a constitutional on statutory right but also a human right. Chairman Indore Development Authority versus M Pure Industrial Coke and Chemical Company AIR 2007 SC 2458. In this matter, Supreme Court decided that right to property is a human right. Thus, it's clear that human right is a legal right. Right. Let's write a short note on Magna Carta, Bill of Rights, French Declaration. Let's write a short note on International Declaration of Human Rights. The roots of human rights are hidden in the depth of past. Its history related to the origin and development of the human civilization, although the establishment of human rights at international level is considered as the first document of UN Charter and the credit of its format as fundamental rights goes to Magna Carta. The river flowed from Magna Carta of human rights is now flowing in many democratic countries. One is Magna Carta. Magna Carta is considered as the first document of England of 1215 to establish the human rights as fundamental rights. It was an important gift of King John to his citizens. He is also known as Father of Fundamental Rights. This rights letter embodied the rule of law in England. The legal suffix due process is yield of Magna Carta. First time in Article 39 of Magna Carta, it was said that no free man is to be arrested or imprisoned or diseased or outlawed or in any other way ruined, nor will be go against him or stand against him except by the lawful judgment of his peers or by the law of the land, such as Magna Carta stop the cruel power of executives. Bill of Bill of Rights, the rights of Magna Carta are created with peace, time, and circumstances, and later in 1689, a document was constructed named Bill of Rights. This document contained many important rights and freedom of citizens. Public enjoyed fully the Bill of Rights. The rights of Bill of Rights has been placed in Constitution, and it was said that no person shall be deprived from life, liberty, and property except the procedure of law. Freedom includes freedom includes freedom of speech and expression. One is freedom of speech and expression. Two is freedom of press. Three is freedom of religion. Four is freedom of assembly. Freedom of residence. Freedom of travel. Freedom of business. Freedom of work and occupation, etc. Hatardo versus California, 1834. 110 US 516. In this matter, it was decided that legislation shall not make any such law. Such stymied the justice and fundamental freedoms of person. French Declaration. Human rights as fundamental rights were declared in France in 1789. The document by which this declaration was done is known as Human Civil Rights Declaration. It is also known as Human Rights Declaration. The rights included in this are nuanced as pure rights of man. These rights are natural. International Declaration of Human Rights in the origin and development of human rights. International Declaration has an important place. So here it is. So here it's brief. The description is appropriate. United Nations Charter. United Nations Charter has its own place in the International Declaration of Human Rights. In the preamble of the Charter, in the preamble of the Charter, deep faith is showed in fundamental rights. The Charter says about the promotion and enforcement of human rights and fundamental freedoms for all without distinction as to race, sex, language, and religion. The Charter had provided extreme powers to economic and social council to promote human rights and fundamental rights. It also created a trusteeship system to enforce the human rights and fundamental freedom in these trusteeship areas. According to later Pent, United Nations Union Charter imposes certain duties on states related to human rights. Universal Declaration of Human Rights. The Universal Declaration of Human Rights is also known as International Human Rights Declaration. It is considered as a historical event in the field of human rights and a great achievement of United Nations Union. Human Rights Declaration 1948 has total 30 articles. This declaration includes basically every point of our dignity full life of human. Every person is born free and is equal in respect and rights. Every person has right to life, liberty and security. Every person is equal before law. No one can be kept as slave. Every person shall have freedom of speech and expression. Every person has right to obtain proper opportunity of development of physical, mental, and intellectual. Everyone has freedom to travel, peaceful assembly, business, or occupation. No one shall be treated as inhumanity. This declaration was adopted by United Nations General Assembly on December 10, 1948. That's why 10th December is celebrated as Human Rights Day in whole world. UN Charter is a significant document of human rights. Let's explain it. UN Charter has an important place in human rights documents and charters. In this character, an important place has been given to human rights. In the preamble of character strong belief has been expressed toward human rights. The main object of United Nations is to enforce and promote human rights and fundamental freedoms without the discrimination of caste, religion, sex, or language. Article 55 has such provisions in Article 56. All the member nations of United Nations pledge that They will try jointly and separately for the object mentioned in Article 55. In character, Economic and Social Council has plenteous powers to promote human rights and fundamental freedoms. Charter Charter has a trusteeship system whose duty whose duty is to apply human rights and fundamental freedoms in trusteeship areas. Louis Hankin said in his creation, the United Nations and Human Rights International Organization in any or every story of United Nations has an important piece of human rights. Later, Paint believes that UN Charter impose certain liabilities on states regarding the subject of human rights. Professor John Hamphy says that UN Charter has established certain rules and measures for human rights. It would be duty of states to cooperate in UN Charter for the protection of human rights and fundamental freedoms. Important arrangements has done. Basically, to regulate human rights till now under international law, no effect full institution is constituted. That's why Professor Oppenheim says it is very early stage in the matter to enforce fundamental human rights. At the San Francisco conference, it was expressed by several delegates that the United Nations should establish an international Bill of Rights. Although that could not be done, it was well realized by the members that it should be the obligation of the international community to cooperate in eradicating the scourge of war, and they were therefore determined that the promotion and respect for human rights, which at present constitute so important and so conspicuous, be an integrated part of the UN Charter. The result was that the Charter contained a number of provisions for the promotion of human rights and fundamental freedoms in the preamble and Article 1, 13, 1b, 55, 56, 62, 2, 68, and 76c, which are as follows. The preamble of the character in its first substantive paragraph laid down that we, the people of the United Nations, determined to reform faith in fundamental human rights, in the dignity and worth of the human person, in the equal rights of man and woman, and of nations large and small. Para 3 of Article 1 of the Charter provided that the achievement of international cooperating international cooperating in promoting and encouraging respect for human rights and for fundamental freedoms for all without distinction as to race, sex, language, or religion shall be one of the purposes of the United Nations. I thank all brothers, sisters, ladies and gentlemen, students, scholars, teachers, trainers, professionals, listener, learners. I thank all respected doctors and directors. I thank all adorable Mr. Manager. I thank all honorable advocate, advertiser, administrative advisor. I thank the most honorable President Mr. Modi ji. Thank you very much. Nice to see all of you. Have a nice day. Nice to see. Thank you.